Hello and welcome to the Divorce Lab. We're a group of independent professionals working to help educate the public on various topics related to divorce. I am Carrie Goldring, a certified divorce lending professional who specializes in mortgage planning.
And I'm Mark Avezai. I'm a certified divorce financial analyst. I work primarily in Troy, Michigan.
Hi, I'm Jim Chryssikos. I'm a family law attorney and mediator located in Troy, Michigan. So let's get started with today's show.
Hi, today we have with us Lauren Dickstein from Lewis and Dickstein, who's a criminal defense attorney. Welcome, Lauren. Doesn't come up often when we talk about divorce and criminal, but we know talking to you, there's a lot of times that it does intersect. So I'm going to let Jim start with you, and you can help us understand how criminal defense comes in our divorce world.
Sure. Yeah, it might come up more than you think, actually, Carrie. I don't know who has better stories, a criminal attorney versus a family law attorney. I would imagine it's neck and neck, but you might have the edge there. But we're not going to trade war stories. I have a question for you because it is not an unusual scenario in divorce cases where a report is made to CPS, meaning Child Protective Services. For those, hopefully not too many people know what that is, but if you know CPS, my condolences. But a report of suspected neglect or abuse gets reported to Child Protective Services. And usually my client would be put on notice, if that's my client, that there's a report made. And I don't do a lot of CPS, abuse and neglect work. So my question for you is that something that you can represent a client on? And what do you do when you first hear that there's been a report made to CPS?
Oh, thank you for the question, Jim. That actually happens fairly frequently. And we receive referrals from family law attorneys all over the state. Many times it involves a complaint made to CPS. Those complaints are almost always confidential complaints, so it's very difficult to find out who made the complaint, although we often suspect it's a spouse who's either recently filed or planning to file divorce and looking to get an advantage either in the divorce case or in child custody proceedings.
So if you know there's a divorce case, are you going to usually make the presumption that it was probably the other parent, the other spouse?
Or a mother-in-law or father-in-law, yes.
Okay.
Yes, that is often the source. And what happens typically is the client will get a call from Child Protective Services or CPS worker who will introduce themselves and say, hey, we've received a complaint. We'd like to come talk with you about it. And they schedule an appointment to come to the home, see the house, and ask questions about the allegation. It's really essential that the person who receives that call, of course, contacts their family law attorney first, but then has a criminal defense lawyer get involved because not only can we help with regard to the abuse neglect proceeding in family court, which could result in the court taking temporary wardship or permanent termination of parental rights in the child protective proceedings, but also could result in criminal charges if a complaint of abuse or neglect is substantiated.
So a quick question, Lauren. This is not a light allegation if it's unfounded or untrue, right? But if it is true and these things are happening, how long does this kind of process take to intervene, to help the children? What does that look like?
So in a situation where a client comes to us and says, hey, I received this call and I did do something that I shouldn't have done. Let's say, for example, physical abuse that was inappropriate, it resulted in an injury to the child. Let's just use that as a hypothetical. In a case like that, normally what we do is, first of all, we would never let the client speak to CPS or a prosecutor or police officer without us present. Secondly, we typically get something called a risk assessment done by a forensic psychologist right away, and so that we can get recommendations as to what they can do to deal with an anger management issue or determine if this was a one-time event not likely to be repeated. And we would get them into mitigating counseling, for an example, to try and prevent a CPS from taking jurisdiction of the child or criminal charges from being filed. That can take really it depends a lot on the CPS worker. Some of them are so quick and some take months. It really could take between 2 weeks and 90 days before you find out what direction it's going to go.
So obviously, if I have a client who is advised or notified that he or she is the subject of an investigation, we know, get them on the phone with you right away. What about if I'm representing in a divorce case, let's say, or any family law case, the other parent, the parent who is not the alleged abusive parent, but they're aware of abuse going on? Because I'm always hearing about, look, certain people have a duty to report. You can't fail to report, fail to protect, I think is what the charge usually is, fail to protect the children from an abusive parent. If I am aware from a client that the other parent is being abusive and my client's not reporting it, what consequence may they have, and should they be talking to you?
Yeah, they absolutely should. And there's two routes they can go. One route would be if they have a cooperative soon-to-be ex-spouse, which may not be likely in these scenarios, but it is the case sometimes. They can create a protective plan for the child right away. The parent who's committing the abuse can agree to only see the child on a supervised basis, can agree to get counseling. That would be a way to avoid an allegation of failure to protect because they're creating a safety plan for the child. If the spouse is not so agreeable, or perhaps the parent might, or the one spouse might be afraid to make a report because they might be afraid of some type of retribution or assault or reaction, then they do have an obligation to make a complaint, because if CPS finds that they knew of the abuse and failed to stop it or take protective measures, they can file a petition to take temporary wardship of the children pending the court protecting the child if a parent, non-abusive parent, failed to do it on their own.
Right.
Gary?
Yeah, it is. And, of course, a lot of people who are going through a divorce case, sometimes they don't always want the divorce. Sometimes they're hoping to reconcile. And sometimes they are reticent. Maybe they're also the victim of domestic violence and they're afraid to report it. I mean, there could be a lot of reasons why a parent wouldn't want to report their spouse to Child Protective Services, but they've got to understand this failure to protect is a real risk.
That's very true. And when you're talking about situations where a parent is also the victim of domestic violence, there's really a reason to consult with an attorney, because what they say isn't confidential with Child Protective Services. If they make a complaint and also indicate that they've been abused, it's very likely the CPS worker will file a police report that will be investigated and potentially prosecuted. If it's a case where they don't want the police involved or a prosecution for domestic violence and they're trying to handle a situation that's rather delicate on their own, they may need to be advised very carefully what to say and what not to say to cause their family maybe a bigger problem that they had planned for.
Total basic question. You say abuse. Is that just hitting? What's our definition of abuse?
No,
Or
it's
what's not abuse?
that's a great question. In 95% of cases, we're talking about some form of physical abuse. There
Okay.
definitely have been situations, particularly where CPS gets involved, and it may not be criminal, or it could be, where there's some form of either physical abuse by having a child do things that are, inappropriate for the child to be doing, like it could be taking care of other siblings when they're very young, 7 or 8 year old. Could be asked to take care of a baby, which one parent might object to and another parent might feel is appropriate. Or we've had cases where children have been denied meals for a day as a punishment. Not something that court is going to allow to happen, but unfortunately, some people, maybe based on their own upbringing, believe those types of discipline are appropriate for children.
You're not talking verbal abuse.
Not generally, although there are occasions where it can be so extreme that Child Protective Services could be involved, or they could just allege neglect as opposed to abuse. Although neglect isn't necessarily criminal in all cases, although it can be if it's severe, it's more likely to be a situation where a court would take either temporary wardship or seek termination of a parent's rights if they neglect the child as opposed to abuse them, meaning they fail to give the care and custody and support that the child needs to just be mentally and physically healthy.
Yeah, I was going to say sometimes it's not abuse, sometimes it's neglect. And I've had clients who have told me usually they're already divorced or they were never married. And, well, I'm hearing that he left the house to go shopping and left the 7-year-old home alone, or even worse, home in charge of their little brother or little sister, leaving kids alone in the car while you go into the store and do your shopping in a car seat. So there's wild things going on that aren't specifically abuse, but they could be neglect, and that's often just as bad.
Well, when a couple's going through divorce, oftentimes that's happening concurrently with other terrible things that might be going on in their lives, employment problems, problems with a family member's illness. Those things frequently happen in times of the tumult or the the problems that come along with family issues that result in divorces. It could be, and like you just said, Jim, I've had many cases where a parent goes with small children to buy drugs,
Oh yeah.
to go see a prostitute. And, obviously, if their spouse finds out that those things are happening, it will not be long before they call the police or CPS to report that type of neglect.
Right.
I'm curious. Obviously, I'm assuming the CPS issue is one of the main reasons, Lauren, you and your firm get brought in on divorce cases from a criminal perspective, right?
That's very common. There's also the other really common way that happens is complaints of domestic violence is one of the most frequent ways that family law attorneys seek to bring in a criminal defense attorney to help their client. And I did want to bring up also, based on what your question is, a lot of people will say, well, let's wait and see what happens. Let's wait and see if the police file charges before you hire a criminal defense lawyer to get involved. And it's so essential that people don't listen to that advice, because I can give you examples. There are many occasions where a complaint is made of child abuse, criminal sexual conduct, or domestic violence. And if we're hired on a pre-charge basis, we can oftentimes interview witnesses, get forensic psychological analysis done of either a child or our client, or look at security camera footage like Ring cameras. And oftentimes we can show a prosecutor that a crime really wasn't committed and prevent the charge from ever happening.
So the way I'm envisioning what you're saying, so if in a divorce case, let's say you've got an incident that occurs in the marital home, maybe one ends up calling the police come to the home, take somebody into custody and place them under arrest, or just ask them to leave for the night. You have someplace to go and get out of here for the night. Under either of those scenarios, is that sort of what you're talking about? So if somebody's not placed into custody and arrested, because you can assume if they're arrested, there's going to be a charge coming, right? But what if they're not arrested? What if they're just asked to go somewhere else for the night, or to allow their spouse to go somewhere else for the night with children?
Sure. Well, even if there's an arrest, there's not always a charge right away. What frequently happens is if the crime that's being alleged is punishable by more than 93 days, like aggravated domestic violence, for example, which is punishable by up to a year in jail, that has to be charged by a prosecutor, who might take weeks or a month to determine what the appropriate charge is. So in those cases, the accused spouse might be arrested, but then released the next day on, it could be an interim bond saying, don't return to the marital residence or have contact with your spouse, while the prosecutor determines what the appropriate charge is. We had a case just the other day where there was a very peaceful, cooperative divorce that was occurring, but a dispute occurred with regard to custody. They just couldn't agree on parenting time. Our client was totally blindsided by an allegation that he abused his 2-year-old daughter when a detective called him and said, hey, we want to speak with you. This allegation was made. We were able to get medical records right away. We hired an expert who looked over the medical records and the alleged injury, which really occurred as a result of a fall. And they were able to give an expert opinion that the mechanism of the injury, or what caused the injury, isn't consistent with the allegation that was made. Once we did that, the detective and the prosecutor said, all right, we're not going to charge this. We don't believe the allegation's true. Had that person not contacted us right away, there's no doubt they would have been charged, and then they would have been defending the case after they'd already been charged and potentially facing a jury, when the whole thing could have been avoided.
See, now I hear that story and I start to tie it in with that whole failure to protect argument, because if in that case the parent who noticed an injury isn't sure how it occurred and maybe starts putting two and two together, or even better, calls their attorney in the divorce case, and their attorney in the divorce case says, well, if you don't know what happened or you have suspicions, you've got to report it, because if you don't, you might be found liable for failure to protect. I mean, is that a possible scenario?
Yeah, absolutely. So in this particular case, is a little different than the hypothetical you're suggesting, because if there was if there was a bruise that was suspicious and someone calls the police or CPS and says there's a bruise, I can't explain it, I know I didn't cause it and I didn't see anything that caused it, it should be investigated. That would be appropriate protection of a child to prevent an allegation of failure to protect. In our case, the allegation was that she was with her 2-year-old child and her soon-to-be ex-husband, and he grabbed the child's arm and twisted it, pulling the child away from her when she was trying to take the child on a play date. When the forensic expert examined that injury, they said it couldn't have been from the skin being twisted. It was from an impact. They were able actually to look at something in the house that the husband said the child fell against, matched it up to the injury, and said it's most likely that this happened from a vertical drop, which was consistent with the child falling, and we avoided the charge.
So all before there's any charges brought, you were able to get all that testimony, all that expert input, and kill it before it ever became a actual charge against that person, huh?
Exactly. And financially, it was obviously to the client's benefit as well, because even though they had to hire us on a pre-charge basis, the fee to represent someone on a pre-charge basis is typically far less than defending them in actual charges in court.
How often, and you might not be able to answer this, but I'm curious, how often does one spouse say, yeah, my spouse abused our child, and then they back off of that charge in the future versus trying to actually take that to court?
No, that's a great question, actually. The allegations of domestic violence and particularly child abuse don't happen that frequently in divorces, although it does happen on a fairly regular basis. A lot of times to someone who has just no idea that their spouse would ever claim something like that. And when an allegation's made to try and get an advantage in custody, divorce, assets that might not really be true, frequently the person who's making the allegation will recant and say, I didn't mean it, or I exaggerated, or I said something that wasn't true. Prosecutors almost never will drop charges under those circumstances. They are experts at showing or attempting to prove that alleged victim was manipulated or is afraid of losing financial support or family pressures occurring that's causing them to retract their allegations. And they figure they weren't there. It's not their job to figure out whether or not it really did or didn't happen. That's for a jury to determine. So it's almost impossible for someone to retract their allegations, effectively causing a prosecution to stop. Prosecutors just don't do that.
Getting a hold of you early is obviously very critical during a situation like this.
The earlier we can intervene, the better.
Yeah, I think it's important
Just
for
what
people.
Mark and I say all the time. The earlier we get in, the better.
That applies to everything, but I think it's especially true with criminal cases. I think it's important for people to know, it's not just parents that report these things. There are people out there, professions, who are mandatory reporters. So doctors, teachers, I think even school bus driver. I mean, it's a pretty long list of people out there, counselors certainly, who are mandatory reporters, meaning if they have a reason to believe that there's child abuse or neglect going on, they have a duty to report it, or they run the risk of losing their license or their job.
Yeah, we had a case not too long ago where a teacher saw that a little girl, she's I think 12 at the time, had a severe bruise on her hand and couldn't explain or wouldn't explain to the teacher how she got the bruise. So the teacher reported it to the police. And ultimately, the father was accused of using an object to hit his daughter's hand. He denied that. That was another case where they contacted us before charges were filed. In that case, we asked the prosecutor and the detective to have the child undergo something called a forensic interview. And there's Michigan as a child interview forensic protocol, which is questions asked by an expert in a way that is designed to get to the truth and determine whether there's been coaching. It's typically videotaped and witnessed by the detective and the prosecutor. And they agreed. Fortunately, before charges were filed to do that, turned out that the girl in the interview admitted that she didn't want to go to school for a test, so she took a weight from her dad's weight set and smashed her own hand with it to try and prevent herself from going to school, but didn't want to admit she did that. So said that her dad hurt her instead. We were able to avoid the charge in that case too, but you know, who would believe that had it not been for us getting the prosecutor to agree to that interview?
Wow.
And the girl had no clue, I'm sure, what she was accusing her dad of.
That's exactly right. She had no idea what the consequences of saying that would be, that her dad would end up having to move out of the house, not have contact with her and her mother and her other sibling, and then potentially go to jail or prison in that case for having done that to his daughter, committing a felony. She had no idea what the consequences of that were. So, you know, she didn't understand the motivation not to say something that wasn't truthful.
Thank you for listening to us today. You can find us on the divorcelab.com. You can feel free to take a look at our other episodes, and you can also leave some questions or comments for us on there as well.